Committee on Corrections and Juvenile Justice to order. We'll begin our day as we customarily do. I would remind members and those observing that Monday is the deadline for committee bill introduction. After Monday, we'll not be doing this anymore. But we do have some bill introductions for this afternoon. I would begin with RS number 21 RS 1009. This is a bill with respect to crimes and punishments, particularly the penalties for buying sexual relations. I'm offering this for introduction today on behalf of Mike Kagi, Shawnee County District Attorney. Are there any objections to this introduction? Seeing none, the bill will be introduced. I'll open it up to members of the committee first. Any committee members wish to offer any bill introductions today? I see none. We will now move on to the public. Are there any persons present in the room or online that wish to offer introductions today? Go ahead, please introduce yourself to the committee, and we need to know RS number, subject matter, content generally, and on behalf of whom you're offering the bill.
Thank you, Mr. Chairman. Committee. Tom Witt with Equality Kansas, and the RS number on this bill is 21 RS 0894. It would remove the sentencing disparity in the so-called Romeo and Juliet statute between opposite sex and same-sex couples. The statute is 2020 SEP 215507.
Are there any objections to introduction or questions? See none. It will be introduced. Thank you, sir.
Thank you, Mr. Chairman.
Scott Schultz, did you have some work for us today?
I did, Mr. Chair. I actually have 4. Can you hear me okay?
We can. Carry on.
Thank you, Mr. Chair and members of the committee. I do have 4 today. The first 3 are on behalf of the Criminal Justice Reform Commission. The last is on behalf of the Sentencing Commission. The first is 21 RS 0931. It deals with amending the parole officer duties statute in Chapter 75 to formalize the use of effective responses to behavior. The second item is 21 RS 0916. It deals with occupational licensing. The bill proposal would adopt targeted amendments to the licensing requirements of occupational licensing boards concerning criminal history. The third is 21 RS 0915. It deals with criminal sentencing. This would amend the non-drug grid to better reflect actual sentencing and reduce downward departures by expanding presumptive probation and border boxes. The fourth, again on behalf of the Sentencing Commission, is 21 RS 1024. This would actually make technical changes to Senate Bill 123 to allow for new risk assessments being implemented by Community Corrections and Court Services as of July 1, 2021.
That's what you have today?
I'm sorry, I don't have more. Thank you, Mr. Chair.
You've done well. I don't want to rain on your parade too much, but RS 0916, as we speak, is being offered by our vice chair in the Commerce Committee, since it related to occupational licensing and eligibility for occupational licensing. So if you would be so kind as to make life easy, I don't have to argue against your introduction if you withdraw it.
Mr. Chair, I would happily withdraw 21 RS 0916.
Sorry for not getting the word to you ahead of time, sir. With respect to the remainder of the bill introductions offered by Mr. Schultz on behalf of the Criminal Justice Reform Commission and the Kansas Sentencing Commission, are there any questions or objections? Seeing none, they will be introduced. Thank you, Scott. Are there any other persons present in the room or online wishing to offer bill introduction today? I see none. We will move on, and I remind you, we will not be meeting tomorrow, but Monday is the deadline for committee bill introductions. So if you've got one, you better get with it because the time's running. On today's schedule, we have two bills scheduled for discussion and possible final action, House Bill 2121 and House Bill 2128. With respect to House Bill 2128, a request was made to the Sentencing Commission to provide some additional detailed information that really went to the scope of the population to potentially be served and its cost. That information, at least preliminarily, has been submitted to me. There's still some work to be done, and in order to assure members have an opportunity to think through and think carefully about any potential amendments to this bill, we are not going to work House Bill 2128. We will revisit it at a future time. But we will proceed today with House Bill 2121, and we'll call upon our favorite reviser, Ms. Scott, to refresh our recollection about the contents of this bill.
Thank you, Mr. Chairman. You're gonna hurt Jason's feelings over there. House Bill 2121 would add a definition for the term absconds from supervision in both the Criminal Procedure Code and for use in parole. The definition would read that absconding from supervision means intentionally avoiding supervision or intentionally making the defendant's whereabouts unknown to the defendant's supervising court services officer or community correctional services officer. And I can take any questions.
Committee questions for Natalie? See no hands raised in the room, nor do I see any online. Committee, with respect to House Bill 2121, is there any discussion or amendments to be offered? Representative Heiberger.
Mr. Chair, thank you. This is definition is a matter of quite a bit of discussion at the Sentencing Commission. Discussions whether the standard should be intentionally or knowingly. I think this is a little more strict. It would prevent situations where the defendant knew he was not presenting himself or herself for supervision, but did not do so intentionally. And I mean, I run through some scenarios, but I think this is the definition that came out of Sentencing Commission by a majority vote, and I would encourage the committee to support it.
Representative Smith.
Thank you, Mr. Chair. And I noted that also in the committee meeting, or the meeting minutes from the commission, that there was actually the language started with knowingly and then was changed to intentionally. I don't know how many people voted for that to change, but in my opinion, it significantly changed the ability to get there. I do have an amendment.
Very well. You'd like to tell us about your amendment? We'll have Natalie and/or Kim have the amendment distributed to the members electronically to be viewed. But if you'd like to go ahead and begin your conversation about what the amendment does, feel free to do so.
Absolutely. So in State v. Dooley, the Supreme Court, and I'm going to explain this a little bit, and I hate to wade into the weeds on this, but it is going to require it a bit. Even though the amendment itself is simply changing a word on the first page and a word on the last page, and that's from intentionally to knowingly. It creates a problem when you get into a various number of scenarios with individuals who don't make their supervision. There are 3 levels of mental culpability. Generally in descending order from highest to lowest, it would be intentionally, and then knowingly, and then recklessly. By changing it from knowingly to intentionally, you change from an idea of general intent to a specific intent. And that specific intent, in this case, would be that the individual had a intent to have a criminal outcome. This is difficult when you're especially talking about somebody who maybe is impaired on methamphetamine or other drugs. In the case of Dooley, I believe it was 5 different substances that he admitted to, and even admitted to absconding, yet it still came up as a problem because the state did not prove that he was absconding, even if he said he was. By knowingly, you are still requiring an intent, but it's a more general intent. That general intent, and I'll just read it to you, would be that, and this, by the way, is not the only definition, but it is the more generalized definition. Placing oneself in a general state of mind to incur criminal liability. That's knowingly. Why is that important? Because when an individual doesn't show up for drug testing, they're not necessarily trying to become an absconder. That's not what their intent is. Their intent is to generally satisfy their addiction that they know could and likely reasonably would result in a criminal action. That's the basis of changing from knowingly or from intentionally to knowingly. And in the end, when you are trying to steer this individual back into drug rehab, into rehabilitation situations, and you're doing it through parole, probation, supervision, if you have no teeth, if there is no consequence because the courts are not going to follow with your strict intent, then you're really accomplishing nothing. So my amendment would simply change what they did in the commission to what they originally had, which was knowingly. And I think that would satisfy what the Supreme Court intended when they said that the legislature needs to define this. Thank you.
Thank you, Representative. Before we go further with debate on the amendment itself, is there a second to the Smith amendment? Representative Owens seconds. Further discussion on the amendment. Representative Carmichael.
Thank you, Mr. Chairman. I was contacted informally, I believe it was yesterday, the days all run together around here, by a current member of the commission whose opinion I greatly respect. And he informed me that not only himself, but a number of other, well, current judges expressed grave concern about the very point that's being raised by the representative. And I'm not on the Sentencing Commission, and I guess looking around, we have one member, perhaps. But I wondered if it might be appropriate to perhaps inquire if someone can inform us a little bit more about the substance of the discussions, because what I hear my friend the representative say is exactly what this former distinguished jurist explained to me. And so I'm in a quandary here as to how the commission arrived at the language it selected as opposed to the language of this amendment. And I wonder if it might be appropriate if we see if someone else could enlighten me. Elsewise, I'm going to support this amendment.
I believe someone else, if they choose to comment on the offered amendment, would certainly be welcome to do so. Is there anyone in the room that would like to do so? Representative Heiberger.
Yeah, and after I'm done, I would appreciate hearing from Commissioner Schultz if he's ready, willing to comment. There was extensive discussion. I mean, I think the idea, well, I mean, I think if the situation is someone who misses an appointment because he's still struggling with an addiction problem or she's still struggling with addiction, I mean, I guess, is that a situation where we want to continue with parole or have parole revoked? I mean, as would likely result from an absconding. I mean, I'm not going to follow my sword on this. I mean, I think generally think that the more strict definition is more appropriate in this case. But I mean, I can't recapitulate all the discussion we had at the committee, and I was hoping maybe Secretary Schultz could.
Mr. Schultz, you are welcome to inform the committee with respect to your recollection of any conversation between members. I have it in my mind for some reason that perhaps you sent an email out to us on this issue. Did you not, or was that another one that had something to do with voting of the committee? I think we've had 2 of those.
Mr. Chair, Scott Schultz with the Sentencing Commission. This was, Mr. Representative Owens had asked as far as the vote, and I did send out the minutes in which there was, I think it was 7-6, I think was the vote that ended up on this. I would join Representative Heiberger, and I can't articulate necessarily the specific issues. What I can say is that obviously absconding is a higher standard when you're talking about probation setting. And so I think that's what the commission members felt, that there needed to be a heightened level of proof involved in this situation. The other instance, and that was indicated in Dooley as well, was there's a difference between absconding and that failure to report. And so there should be a heightened level of proof that is required to show absconding. Otherwise, with absconding, the court can bypass those graduated sanctions and send the defendant directly to prison. That's what's at stake here in terms of being able to determine whether or not the individual has absconded. If they can't reach that level, then they have to exercise those graduated sanctions, which would include jail sanctions.
Thank you. Scott, correct me if I'm wrong on this, but basically this question is before us as a result of an appellate court decision that made it fairly clear that the legislature to date has failed to adequately define what absconding is within Kansas, within the context of Kansas law, and that when we get into the issue of intentionally or versus knowingly, it is really the level of proof that really has to be demonstrated to achieve a finding that there was a violation. Am I pretty much on track so far?
Yes, that would be correct.
And would it also be fair to say that in cases of motions to revoke probation or parole or any community supervision, that the court would hear the evidence, would hear more about the individual circumstance of the offender, maybe what contributed to or didn't contribute to the event that resulted in the motion for absconding, and that the court could weigh all of that and in its determination of the disposition take that into account as to whether or not to send someone on to prison?
Mr. Chair, they certainly could. I would note that there is no discussion as far as utilizing a knowingly standard in the Dooley case. Intentionally is used several times.
Thank you. Committee, any other committee members wish to seek to achieve clarity by inquiring of Mr. Schultz? I see no hands raised. Well done, Mr. Schultz. Well done. Committee, further discussion on the motion to amend. Representative Carmichael.
Thank you, Mr. Chairman. I appreciate Mr. Schultz and my colleague, the ranking member's attempts to educate me. This issue was presented to me in a somewhat different context, however, and it was presented to me as under the stricter standard, which I think is intentional. virtually everyone who needs to go back to the pokey can say, well, I knew, but it really wasn't intentional. And as a result, people who need to be on their way back to jail get a get-out-of-jail-free card. And I understand we have an emphasis on trying to keep people in programs and out of prison, but there are people who do need to go back to jail. And so on this one, I may have to reserve the right to flip-flop by the time we get to the floor. But I'm not at all sure the bill in its present form is necessarily what we want, but I'm not certain enough to try to influence anyone else in that judgment.
Committee, other discussion on the motion to amend? I see none. Representative Smith, you can close.
Thank you, Mr. Chair. And I respect the explanations given by the representative on the commission and by the commissioner. I think the representative who previously spoke is correct. I think there was an intention by the commission when they changed these words. And specifically for that, the compassion we have for those who are addicted and the fact that that addiction could get them back into incarceration. On the other hand, the reason why we have supervision is an attempt to give them an opportunity to write that while under supervision, and failing that, what else do we do? The commissioner is correct. There's plenty in State v. Dooley using the word intentional. I would remind the committee that knowingly is a level of intent. It's a general intent. No doubt an individual needs to have knowledge that what they're doing could end up putting them in the position that they don't want to be in. That's all knowingly is. But they have to have an intent, a general intent, to make the commission or to commit the act that will put them in those circumstances. So given that, I'll move my motion.
Thank you, Representative Smith. Committee, you've heard the Smith motion to amend. On the motion to amend, those in favor indicate by raising a hand, please. And those opposed, please raise your hand. It appears to me that it's an 8-3 vote in favor of the motion to amend. The motion to amend passes. Is there any challenge of that? Representative Carmichael will be shown in the minutes of voting in the affirmative.
He who lives by the sword dies by it,
There you
so
go.
write it down this time that I was affirmative.
Representative Heiberger will be reflecting a no vote. Representative Owens, an affirmative vote. Any others wishing to have their vote recorded? I see none. We're back on the bill as amended on House Bill 2121. Any further discussion or amendments to be offered? I see none. What is the will of the committee with respect to House Bill 2121 as amended? Representative Heiberger.
Mr. Chairman, I move that the committee recommend House Bill 2121 favorably for passage as amended.
Representative Smith seconds. Discussion committee. Seeing none, those in favor of recommending House Bill 2121 as amended favorably for passage, please indicate by raising a hand. Very good. Those opposed? Motion passes. The bill will be reported favorably as amended. I believe committee, unless anyone else, Representative Carmichael voting in the affirmative, Representative Heiberger affirmative, Representative Owens affirmative. Any other members wish to have their vote recorded? Seeing none, I believe we have come to the point of completing our work here for today. We will meet again on Monday. I wish everyone safe travels and a good weekend. Thank you for your attendance, and we are adjourned.